And we're here today once again with Honorable Paul Catanese, presiding judge of the municipal courts of the Mercer Vicinage, who recently retired. We've got to talk about another extremely important topic for attorneys and judges to know about, especially judges, and that deals with bail. All right. I was thinking about the best way to broach this subject, and the easy way to start it off is to go back to our state constitution, which provides that everyone in our state who's charged with a criminal offense, except those who have death penalty cases, is entitled to bail. And since we don't have any more death penalty in New Jersey for the moment anyway, everyone's entitled to bail, just by definition. That's the easy part. The hard part is where you get involved in determining what, when, how, and where the bail is going to be. So I want to know if we could spend a few minutes talking about that. And I wanted to start off with the most important type cases, and those are the ones where you'll be setting bail for individuals who have been charged with criminal offenses. Bail, though, that's within the authority of the municipal court judge to set, as set forth in the rules of court. Could you talk about that generally, Your Honor?
Sure. We can set bail on almost all offenses. There are a class of cases which are set forth in the rules where we cannot set bail, and those would be things like murder, sexual assault. There's a host of those, and we just are precluded from setting bail. And some relating to violation of restraining orders as well. There's restrictions on what we can do. Mm-hmm. But aside from that, municipal court judges can set bail, and court administrators and deputy court administrators within certain parameters can also fix bail. So in most cases, the judge will be involved, and of course we're only dealing with cases where a matter is on a criminal case which is on a warrant. It would not involve anything on a summons, and that is pretty basic, but sometimes we run into a problem where someone is set bail on a summons, which can't be. The warrant is really deprivation of liberty, and the court rules and the statutes provide that, in fact, the court has the authority to set monetary bail and also terms and conditions for individuals charged with criminal offenses.
Well, that being said, let's talk about some of the specifics involved. Now, my understanding is that in the rules of court, that the ability of a court administrator or a deputy court administrator to set bail really, first of all, has to be done under the authority of the judge, in the sense that the judge has to grant them individually the authority to do that. Would you agree with that?
Absolutely. And the judge, it says, has to grant the authority. There's no requirement to be in writing.
Right.
But the practice should be that the judge signs an order authorizing the court administrator and deputy court administrator to fix bail terms and conditions within the parameters set forth in the statewide bail schedule.
I know that the deputies and the court administrators receive training with respect to setting a bail generally, but do you think if a judge is going to authorize his staff to set bail, that there should be some individualized training so that the judge makes it clear what he expects or what she expects in terms of the bail that's going to be set?
Absolutely. When you're going, it's just not signing an order saying that I'm giving them this authority. You need to sit down with them and say, okay, you've been given this authority, and here's what I'm looking for, and this is what my expectations are. Now, again, remember that it is within the parameters set within that bail schedule. They can't deviate from that schedule at all. Mm-hmm. So there are restrictions. So, and the rationale behind that was, if we're not having a judge making those determinations, we don't want to give them too much discretion in what they can do.
Once, though, that the judge has authorized either the deputy or the court administrator to set a bail in a particular instance, is there any distinction between what they can do and what the judge can do?
Well, again, those parameters are set, and the imposition of terms and conditions, in my opinion, should be left to the discretion of the judge. Right. So we've seen this where an individual who is a court administrator deputy will impose terms and conditions as well. Right. And we've had discussions at the state level on this as well.
Do you think that this is authorized under the rules of court?
I don't believe it is.
Let's say, for example, an individual arrested on some type of offense, assault of type conduct, not domestic violence, and a judge might set a condition of bail, $500, no contact, not to be released until sober. Okay. which would be perfectly reasonable bail conditions. Would you think, though, that a deputy court administrator or a court administrator has the authority to make those same conditions of bail along with the cash component?
I think that the monetary component, they have the authority, that's the bail schedule, but I don't think they can add terms and conditions. Okay. I don't think they can do that.
So unless they would call the judge and get authority from the judge?
Right,
okay.
Right. And then really it's the judge who's setting those terms and conditions.
So there is a qualitative difference in terms of what a judge would set as a bail in terms of deviating from the bail schedule and also setting terms and conditions. Would you agree?
Absolutely.
Now, getting back to the really serious cases, not the ones where the bail decision is taken out of your hands, the murder cases, the aggravated sexual assault cases, the most serious possible crimes that we have in New Jersey.
Well, what's interesting is that none of those deal with attempts, which is pretty interesting. The attempted murder is we can set bail. Murder we cannot.
How about conspiracies? Can you set bail on conspiracies too? I've never thought of it. I don't know the answer.
I think we can.
So it's just the substantive offenses, not the attempts or the conspiracies.
Yeah, yeah.
Putting this class of cases to a side where you're going to get a judge of the Superior Court to set the bail, what are the things that you take into consideration when setting a bail? And let me give you two situations. Situation number one, the police are going to go out and arrest an individual, and they come to you and they want a warrant prepared. Or they've prepared the warrant, they give you an affidavit of probable cause, you read it over, you say, yes, you've established probable cause here, I will now sign the warrant. Would you set bail at that point, or would you let the police go out and effect the arrest first before you set the bail?
Generally, I would want the person to be in custody to set the terms and conditions. But I think a lot of judges will set the bail, although on domestic violence matters, generally bail is not set until the person is in custody, and that has something to do with a statewide system and how the person is entered into the system.
But I mean in the criminal context. Let's say the police want to go out and arrest someone for some type of weapons offense, firearms offense.
Yeah, not in custody, I'm not going to set bail. I want the person in custody because they may have additional information for me at that particular time. We need to deal with a whole host of issues at that point. And I'd like to have a complete picture before I set the bail.
So you will basically then, at this point, then you'll authorize the arrest warrant for the individual, but not necessarily consider the bail until the defendant's in custody, because it's really not in play, so to speak, until the defendant's in custody.
That's right.
Now, assuming the defendant has been arrested, how long typically would it take for you, or how long do the court rules provide for you to come up with a bail for that individual? Once the police tell you, look, we've arrested this individual, he's here.
You need to do it within 12 hours.
Okay.
So it's really important that once that happens, that the police get in touch with you. And we've run into circumstances where the warrant has been authorized, the person is arrested,
right,
and then the judge won't be contacted in time, and then you run into an issue. Or, in the alternative, the police prepare it on a warrant. They've arrested the person, now they prepare a warrant,
right,
and they then release the person on bail, which they have set off the bail schedule, before even process is issued. Because the police can arrest the person and then prepare a warrant.
But a judicial officer hasn't signed the warrant yet.
Hasn't signed off on it yet. Right. Bail can't be set off the bail schedule or anywhere else unless the warrant has been authorized.
Right.
So, and I would say to the police, well, tell me how you could possibly set bail when the warrant hasn't been authorized. Well, the person came in to post the bail, we wouldn't let the person go, and, we wouldn't want to, inconvenience them any further. You just can't. I mean, you can't do that. So they're sort of mixing apples and oranges there as to the process. It
reminds me of a fairly recent case. It was the subject of a published opinion from the Supreme Court, as a matter of fact, in Bergen County, where the police went out and effected all kinds of arrests, and the warrants had not been signed, but they they went and arrested the person anyway, thinking that the warrants had been signed. But I want to kind of go back to, because I want to talk about setting bail in terms of real-world issues that come before municipal court judges. So your advice then, in the situation where the police are going to go out and look for the guy, go find him. When you've arrested him, call me. He's entitled to have bail set within 12 hours.
Right. And you see, some of the thinking of setting the bail immediately was that if it's 2 o'clock in the morning, and the judge has been awakened, let's say, 2 or 3 times during the night, that you don't want to call the judge back at 4 o'clock again for him to set bail or her to set bail. Because, judges, municipal court judges, we work during the day and then we work during the night. There's no such thing as, okay, I'm off. I mean, the job is 24 hours a day. So you can have a judge who's been up all night dealing with these issues, and the police may be sympathetic and say, Judge, I don't want to have to call you back in 2 hours. We're going to pick this guy up right now. And I don't want to call you back and have you set bail now. Can you set bail at this particular time? Well, the judge has the authority to do that, but I generally want to wait. Here's the bottom line, though. The 12 hours is from the time that the person is taken into custody.
Right.
So you don't have to call them back at 4 o'clock in the morning. You can wait until 10 o'clock in the morning when the judge is attending to other business, whether it be in court, in chambers, or maybe in private practice. So reaching the judge at a reasonable period of time. That's why they set the 12-hour window, so that you didn't have to keep bothering the judges.